and thank you for joining this webinar. My name is Mary Lawrence and I'm a partner at Osborne Clarke and I lead Osborne Clarke's Health and Safety team. And I'm joined by Katie Vickery, one of my fellow Health and Safety Regulatory Law partners. This webinar follows on from a written update report that many of you may have seen that Osborne Clarke prepared in conjunction with the Institute of Occupational Safety and Health, examining the impact of new guidelines introduced into the UK court system last February, essentially assist judges in determining the level of penalties that could be applied in health and safety cases which are heard in the criminal courts. Now, some of you will be familiar with the UK regime on health and safety criminal enforcement and the sentencing landscape prior to February 2016, but some of you perhaps less so. The purpose of this session, therefore, is to provide you with a more detailed picture on the current position, which will be relevant to all businesses operating in the UK and to any of you who might work for businesses that invest in businesses in the UK. The other session is to help you understand more about the law, the enforcement regime and the penalties associated with breaches in health and safety law in the UK, and also to provide you with some practical tools to take back to your business. As this isn't a live webinar, you can't ask questions as we go along. At the end of this presentation, you will see a slide with mine and Katie Vickery's contact details and email addresses. If you have any queries, please drop a line and we'll be pleased to help you. To start then, a brief summary on the topics that we're going to cover. We're going to look at a short recap on the legal duties in the UK in relation to health and safety to which the sentencing guidelines relate, anticipating, as I say, that some of you are going to be more familiar with this than others. We're going to look at a background as to why these changes in sentencing have come about, really to help you understand a little bit more about the whys and hows of these changes, which we hope will help you discuss these within your own business. We're going to then look at how the new sentencing guidelines actually work. The guidelines are publicly available, you can search for them and download them, but we're going to take you through a high-level overview of how they might apply to your business in the event that your business is facing a prosecution. We're going to look at the impact of the change in sentencing in the UK for health and safety offences that we've seen over the last year, a few cases and lessons we've learned, and spent really a bit of time in that area. Finally, we will take you through some ways in which your business can help guard against the legal risks associated with a health and safety prosecution. Katie's going to pick up on some takeaways for your businesses, irrespective of whether you're facing enforcement action currently. More importantly, we're going to talk about ways in which we might avoid enforcement.
Thanks, Mary. So if I could just pick up first on the legal duties that exist in health and safety law. And to begin with, just to emphasise that these are all criminal liabilities that we're talking about. Turn to the Health and Safety at Work Act 1974, and this places some general duties first on employers. We see it section 2.1, and that's duty on an employer to ensure, so far as is reasonably practicable, the health and safety of its employees. But the duty also extends to non-employees, so to contractors or visitors or even trespassers under section 3.1. The duty under section 6, and that's the duty that you have when you're supplying materials or goods. They have to be, you have to take health and safety into consideration. And finally, the last two, section 7 and section 37, are duties that are imposed on individuals. Section 7 is a duty on everybody to ensure their own health and safety and also the health and safety of those around them. And section 37 is a specific duty on individual directors or very senior managers, where they can be personally liable if it can be shown that a company has committed a health and safety offence and that director was aware or could have been aware of facts that led to that health and safety offence because they either consented, meaning they actively knew and consented to the actions that contributed to the breach, or they're connived, meaning they turned a blind eye, so they ignored a set of facts or a situation and allowed it to continue, or exercise neglect, which means they did not know about the set of facts that led to the breach, but they would have known because it was within their job description. There's also second legislation that flows from the Health and Safety at Work Act. We know these, or the most key bits of regulations, as the six-pack regulations, and they include a number of core obligations, including things like writing risk assessments and how you manage health and safety generally within a workplace. There are many regulations that from this cover all aspects of health safety. Finally, to pick up one area which is covered in the sentencing guidelines, and the Corporate Manslaughter and Corporate Homicide Act of 2007. Many will be aware that the Corporate Manslaughter Act came into force on the 1st of May 2007, and the purpose of the Corporate Manslaughter Act is to place an obligation on a company if the way in which its activities are managed and organised cause a person's death and amount to a gross breach of a relevant duty of care. To assess this, a company is looked at according to the activities of its senior managers and looked at in terms of how they organise themselves and how they manage the business. Those activities are then assessed to decide whether or not they caused a person's death and whether or not those activities would amount to a gross breach of the relevant duty of care, meaning that the breach was so bad that it should be deemed criminal. It is a corporate offence and not an offence against individual directors.
Then we wanted to look at why this change came about last February and why is the change in sentencing so significant? Well, very important because the guidelines introduced in February 2016 have completely shifted the landscape and the way in which health and safety and corporate manslaughter cases are sentenced. Prior to February 2016, large organisations and small organisations would be faced with would only be faced with some guidelines telling the court how to sentence them in the event that the health and safety breach had amounted to and had resulted in a death. So new old guidelines that existed stated that for fatal cases there should be a starting point of £100,000 fine for health and safety cases or £500,000 for corporate manslaughter. For those cases falling outside of that definition, i.e. non-fatal injury cases or cases where there was no injury at all, there were no guidelines for the court at all. Commonly that meant that the threshold of even £100,000 was very often not being reached. Therefore, now that we're faced with guidelines that definitively tell the courts how they might approach that, we have started to see much, much larger fines, with fines in the millions of pounds being the norm. More on that in a second. So where has this shift come from? Well, one of the reasons this has been looked at is because of the lack of consistency in courts as how issues are being approached, and judges were commonly indicating that they did need some greater guidance, these cases perhaps not being that familiar to them. But one of the things that was coming through very clearly from cases that were being heard, particularly those in the appellate court, was that the purpose of penalties in this arena should bring the message home to directors and shareholders about why these breaches are so significant and to actually effect some change. One of the areas where we had seen this prior to February 2016 was in the environmental arena, where guidelines were introduced a couple of years in advance of these health and safety guidelines. And shortly after those guidelines came into force, fine that had been imposed against Thames Water was taken to the Court of Appeal. Thames Water appealing the fine that had been imposed against them of £250,000. And the circumstances of that were very different from health and safety cases. It was to do with an untreated sewage discharge into a waterway caused by a blockage of pumps which were designed to move sewage into plants further downstream. The impact of the discharge was a serious impact on aquatic organisms, and there was detail presented to the court in that instance about various issues, about warnings that were provided to Thames Water about the issue, and also the business had a number of prosecutions. The business felt that the fine imposed of £250,000 was inappropriate and too high, and the Court of Appeal ultimately rejected that, not only saying was that fine appropriate, but that actually fines should be imposed and may be imposed in multi-million pounds to ensure the appropriate impact on organisations who failed in that duty. And that certainly tells us a lot about the general environment in the sentencing courts about all regulatory cases, but in particular here its application to health and safety cases. Not only has this resulted, these changes have resulted in very large fines, but we've interestingly seen just today, at the end of March, a fine imposed on Thames Water, the third one since that fine, of many millions indeed. So we can certainly see that upward shift is continuing. So what is the difference between the old sentencing guidelines and the new ones? Well, as I've indicated just now, previously, before February 2016, there were only guidelines for fatal cases, and now guidelines which apply to all cases. It was specifically referenced previously that there would be no differentiation between company size, and that the courts should be thinking about attaching fines to turnover. Now the new guidelines identify companies with reference to their size, and the brackets of fines are with specific reference to the turnover of those businesses. So you put into a category based on your turnover. As I indicated, the starting point previously for a health and safety at work offence in the fatality scenario was £100,000. Fatal health and safety cases committed by large companies now could be carrying fines of up to £10 million upwards, up to an unlimited amount. And for corporate manslaughter cases, the bracket in the guideline of which the court can go beyond that bracket is a £20 million figure. So very large sums indeed. So some headline points there to summarise. This is really a complete retreat from the previous position that there should be no tariff for health and safety cases. There's been a dramatic increase in fines, and there is also something I haven't touched upon yet. Under the new guidelines, a much greater likelihood for custodial sentences for individuals, including, as Katie referenced earlier, company directors who may face a prosecution. Just taking you through then at high level how these new guidelines actually work. The guidelines are based on a step-by-step approach. As you can see on the slide there, we've highlighted 4 key steps. But if you reference the document yourself and go through it, you'll see that actually there are a number of other steps that can be looked at. The starting point, and one of the most important starting points for a court, is to first of all determine what offence category a business fits into or an individual fits into. And that is by reference to 2 things. First of all, looking at culpability, and that I mean how far short has the defendant, business or individual fallen short of relevant standards, looking at questions like what measures were in place at the time of the incident or the issue arising, the extent to which failures maybe ran through different levels of the organisation, and perhaps whether there were any warning signs indicating a risk to health and safety. Alongside that will be looked at harm, and by that I mean the seriousness of harm risked, which is the actual wording here. So there is no need for actual harm in these incidents, that the harm could be a risk which hasn't happened but could happen. So the most serious type of incident will be if there's a high likelihood of risk of death or serious injury. So you've got high likelihood and then the most serious type of risk, and that will give you your harm category. Factors that can move either the harm or culpability bracket up the scale include things like the number of people who might be exposed to that harm, or the whether the actions of the defendant were a significant cause, so causation arguments. Having identified what categories a defendant, business or an individual fits into there, what can be then done is, with reference to the company's turnover, the company will be put into a bracket of micro, small, medium or large based on their turnover. So large, for instance, being £50 million plus, medium 10 to 50, small to 10. You can simply follow the table through and you will find that the bracket for a fine and also the starting point, and that is what, if a judge is following the guidelines closely, one would expect them to be looking at. We have been asked very often whether, when calculating, well, what type of company we're dealing with, are we dealing with small, medium, large or very large, and I'll come to very large in a second. What are we looking at? Which company's turnover? You'd be looking at the company that is actually has faced the prosecution, the actual entity being prosecuted. Can group accounts be taken into account? Well, they shouldn't be, based on the facts of the prosecution. The only relevant entity is the company we're dealing with at that particular account. However, if that company is unable to pay a certain level fine, or if there is evidence about very close interaction of financials between them and, for instance, the parent, then it is possible they'll be looked at. I should reference the very large company category. That is if a company's turnover greatly exceeds £50 million, and that is something where there are no brackets above those levels. So the 10 million and 20 million top of bracket figures I gave you at the beginning, the court could move outside that, either because the company was very much larger than £50 million, or perhaps because the harm and culpability and facts of the case were much more significant. Just moving through the other steps, having reached that bracket and thought about the things that we've just been through, the judge then should be taking stock. It is at that point the judge will think about issues such as what the actual profit, so let's not just talk about turnover, what are the actual financial arrangements within the business, and we'll also think about loan account, pension provisions and that type of thing. And we'll generally look at whether this is proportionate and appropriate. And then step 4, there could also be factors based on the impact a fine might have on, for instance, employees. Could it put people out of business? Service provisions, are we talking about public sector, for instance, where a fine could prohibit a public sector service being continued? And finally, as one would expect and have expected even before these guidelines were introduced, issues will be looked at that stage again, just to make sure really that this fine is appropriate. have all the aggravating and mitigating factors being taken into account properly? Does this fine appropriately reflect a punishment which should be issued against the business? And at that stage, then the judge will discount it if there has been an early guilty plea, if there has been a high level of cooperation by the business, etc. Just touching briefly on corporate manslaughter in terms of the new guidelines and how that works. The guidance here increases the threshold very significantly from that starting point of £500,000 that we talked about earlier. What I can say is the guidelines haven't been fully practiced, if I can put it that way, in relation to corporate manslaughter cases, because there hasn't been a corporate manslaughter prosecution, successful corporate manslaughter prosecution of a very large business or large business. So we will no doubt see that in due course. We're going to talk about the impact that the change in sentencing has actually had on health and safety cases over the last year next, and spend a little bit of time on that, both in terms of these figures and on a couple of cases which we think are interesting. So for those of you who were directed to this webinar, perhaps having read Osborne Clarke's recent report with IOSH, you will have seen that we carried out with IOSH a Freedom of Information Act request in 2016 to obtain the information that you see now up on the slide. And what's interesting is when looking at the change in sentencing with reference to fines over the last 3 years, the statistics seem to speak for themselves. In 2016, all of the 20 largest fines that year were over £100,000, whereas in 2014 only one case got to that level. This fine in 2016 was 2.5 times the largest fine of the year before, and almost 10 times more than the largest fine in 2014. And finally, 19 companies received fines of £1 million or more in 2016, as compared to only 3 in 2015 and none in 2014. These figures are distorted because in our Freedom of Information Act request we've only asked for details on the largest 20, and is the effect on small and medium companies proportionate to their financial means? Well, is it similar? Well, we think it is. The Health and Safety Executive are due to shortly publish their 2016-2017 report, which will give us more detail. But based on the information that we have so far, and the final interesting statistic, in the HSE's last report, so 2015 to 2016, there were 660 successful prosecutions brought by the HSE in that period, with total fines amounting to 38.3 million. By adding up the top 50 fines for calendar year of 2016, we get to 38.5 million. So it seems very likely that when we get the statistics this year, you're going to see that yes, fines have dramatically increased across the board, and not just for those household names and those ones that make the top 20 of the list in 2016. And certainly that would be in line with what the sentencing guidelines are seeking to do. I was looking at the numbers. I wanted to give you some insights in terms of what the new guidelines, the impact the new guidelines have had in a number of cases over the last year. And the first couple of I wanted to talk about look at the impact of the guidelines for cases where there has been no actual harm as a result of a health and safety breach, and a company has been sentenced accordingly. You may be familiar that in the UK, a prosecution can be brought if inadequacies within a business can be seen to have exposed others to the risk of harm. So the law doesn't require actual harm to have occurred for a prosecution to have been brought. and it simply requires employers to ensure the safety of employees and other people affected by the business undertaking so far as reasonably practicable. Being said, historically, health and safety prosecutions involving actual harm have been much more frequent, and fines have been much higher than those which might be considered near-miss incidents, or perhaps ones where it just hasn't been possible to prove a causal link between a harm and a failing by a business. But two recent cases have explored this issue in 2016 and have seemed to alter the position in that regard. So firstly, ConocoPhillips, prosecution of a company with a UK turnover of 4.82 billion, described by the HSE in the case as a corporate behemoth. That business was prosecuted following an offshore gas leak on one of their platforms in the North Sea. Now, the leak didn't actually injure anyone, but in prosecuting, the HSE recognised that there was the potential for harm, including the risk of serious injury or death of 66 workers on the platform had there been an explosion. In short, if this had resulted in an explosion, we would have seen something more significant than the Alpha Piper disaster back in the 1980s. In sentencing, the court certainly identified that. They indicated that not only did they consider there to be clearly a health and safety breach in this case, something which ConocoPhillips had pleaded guilty to and at the earliest opportunity, but because of the severity of that risk, that the business should be sentenced at the upper end of the scale. Although that case was heard before the new guidelines came into play, the court determined that had the new guidelines been in effect, the harm category, it said, would have been category 1, which is the highest category, calculated by determining the harm risk would be harm of death or serious injury likely to occur. The court in this case imposed a fine of £3 million after it had discounted by 1/3 for an early guilty plea. And now had that been sentenced under the new guidelines, on that basis it could have been much higher indeed. The second case, which deals with that issue of harm, is a prosecution that was brought against G4S by the local authority, which was after the guidelines had been introduced. The case dealt with findings against G4S that there were a number of inadequacies in the maintenance of its water systems within one of its buildings, and that G4S had ignored the advice of auditors to fix the problems which could promote the growth of Legionella bacteria. In this instance, Harlow Council's environmental health officers had launched an investigation in October 2013 after a resident an employee who had worked for G4S contracted Legionella's disease. Now, for their investigation, the council came to the conclusion that it couldn't actually prove a link between that individual's disease and the inadequacy of G4S. However, it identified and alleged that there were serious issues with the building's hot and cold water distribution system, which had been identified in a previous risk assessment and hadn't been addressed. When it was heard at court, it presented that there were up to 200 people who'd been working at the site along with contractors and visitors who could have been affected. It heard that there was health and safety documentation in place, but that one of the issues was that a Legionella consultancy had been employed, a risk assessment had been carried out back in 2012, identifying a number of high-risk issues, but those issues hadn't been appropriately acted upon. And in that case, despite, again, the risk of any actual link to a disease or injury, the court nonetheless fined the business £1.8 million, again reduced by the 1/3. Moving away then from, as we've learned on cases about harm, the next couple of cases I wanted to look at reinforce some of the principles on health and safety sentencing that we already know. The first two are prosecutions of two separate companies, KFC and Wilko, both retail businesses who face prosecutions under the new guidelines, providing an insight into that idea of what is the norm now and what is the direction of travel in terms of how courts will approach these things. KFC was sentenced in January this year, 2017. Two separate incidents in restaurants involving employees who suffered scalding injuries as part of through their employment in separate years. One of those employees was a 16-year-old, not long been working at the restaurant. The second was a very experienced female member of staff. The court heard in that case that one of the core issues was that protective gloves were not being used in its restaurants in those two cases to protect against burns, and that health and safety procedures weren't being followed. And despite the very good mitigation that was provided by KFC about what it had done to invest in health and safety, generally a figure of £7.5 million being provided, the chain was nonetheless ordered to pay £950,000 in fines and £18,700 in costs. So those were two instances where some serious injuries, no death, but fines of around the £1 million level, just below that. Wilko was another retailer case. In that case, it was again not a fatality, but a very serious injury which resulted in an employee ending up in a wheelchair with a coming disability as a result of the incident. She was a 23-year-old worker who had become pinned under a metal cage of paint. She was pushing in a store in Leicester when the roll cage had overloaded and toppled onto her. The prosecution described it as a high culpability case. There was no risk assessment for the lift or the use of roll cages, inadequate training and supervision, it was alleged. And in that case, the company was fined £2.2 million. So again, large business, significant injury, significant culpability, fined at 2.2. The next two cases, though, of Tesco and David Lloyd, again, two separate cases, I've just put up there because I thought it's interesting to remind people that just because there is a bracket doesn't mean that the court can't go beyond that. And in this instance, in these two cases, the court decided that it would go beneath the bracket to reflect some exceptional mitigation. One of the cases, the cooperation of the business with the regulatory authority, and the other, evidence of good corporate character. And these are important without going into a lot of detail, just to flag up that the courts can indeed move from the guideline to reflect the fine that should be imposed. Just touching on those, the Tesco case was a 2016 case, dealt with the fall of a maintenance worker through a fragile roof light doing repair work. Because of the level of culpability and harm factors, the fine ought to have been within the bracket of $800,000 to $3.25 million, with a starting point of $1.3 million. However, the court found that cooperation had been extremely high by Tesco's. It had provided its internal investigation report, and the court thought that the fine that should be imposed was £500,000, so below that bottom level of £800,000. And the David Lloyd case, a case where a 5-year-old child had been left to drift off in a swimming pool unsupervised and had been rescued but could very easily have died. The court was particularly impressed, again, with level of cooperation and also the response of the business following the incident. The steps had been taken, and the court was content that this incident could never happen again. And again, the fine in that case was ended up falling very significantly below the bracket to which it should have applied. I'm going to just touch on the impact on individuals was something that we haven't focused on in any huge detail, simply to flag up to anyone concerned about that point that if one goes through the section for individuals under the new sentencing guidelines, you will see that if a defendant is facing allegations that they fall into high or very high culpability bracket, that can have a very real effect on those individuals. High culpability for an individual facing a health and safety breach means that at minimum they're alleged to have had foresight of or willful blindness to the risk, but the risk anyway. So hopefully we don't see too many of those cases, although it's possible. But at worst, it would be alleged that in cases there's an intentional flagrant disregard of the law. Those cases, individuals are almost certainly now going to go to prison. But probably more importantly, even if one argue that an individual falls into a much lower category, so much lower harm, much lower culpability, category 4, the lowest category that you can possibly be in harm and culpability, is the only bracket where an individual can be sure that if the court follows the guidelines that they're not going to go to prison. There's no custodial option available to the court. And the practical impact is that a number of defence counsel have noted that they often find the prosecution pitch their cases very high, only changing it later on. And that effect is that for many individuals facing a prosecution, the threat of prison hanging open for a very long time. Finally, the case of Embrace All Limited is an interesting one to note when looking at that question of whether or not the courts might look at the turnover of other businesses. This was a case about a resident with dementia falling down the internal fire escape at a care home provider's home. And what it dealt with there, this was a company which operated 50 residential homes with a turnover of 13.2 million, putting it in the medium-sized business category. That the guidelines flag up, as I sort of briefly referenced, that normally only information relating to the organisation before the court will be relevant, but they do note in the guidelines there may be circumstances where it's demonstrated to the court that the resources of a linked organisation are available and can be taken into account. And that's exactly what happened here. So along with its other business units, the particular home was registered as a separate company, but the defence argued successfully that the court assessed. The defence argued that the court should assess on its turnover alone, but the judge decided that it would take into account the income of the group's entire residential care facilities and set a sentence, or gave a penalty of £1.5 million after a discount for early guilty plea. So no doubt there will be other cases which explore that issue, but at this stage that is a simply useful one to be mindful of, along with the general principles I've spoken about.
Thanks, Mary. So now we're moving on to think about what businesses can actually do to go against the legal risks associated with a health and safety prosecution. And I've included here a slide that sets out a well-known management standard of plan, do, check, act. And this is based on some guidance that the Health and Safety Executive have produced with the Institute of Directors as a guide for what senior management and board directors can do to help institute health and safety within their business. And you see, just starting at the top with plan, it's helpful that a business can put in place a comprehensive policy and can spend some time to understand the key risks to business, either by way of a risk register or another means to sit and identify what the key priority areas are. For directors and boards, it's important that health and safety should appear regularly on the agenda for board meetings. It doesn't always have to be the number one item, but certainly having it as a standing agenda item is useful. And it's also helpful where you have a director on the board who is going to be the champion for health and safety, who makes sure that they are reporting to the board on information, but also making sure that health and safety is a priority in everything that the business is doing. Another way that a business can plan in terms of health and safety is to think about setting some targets or some KPIs, which will set out the priorities for the board, what they want to achieve in terms of health and safety strategy, and that can then provide some focus and some measurable targets that businesses can work to. Moving on then to do. Well, do is all about taking that strategy and the thoughts that have been put in place during the planning stage and delivering that effectively through a health and safety management system. It's important that the board and senior managers deliver on the health and safety policy by providing visible leadership, meaning that people are actively out there on the shop floor, talking to colleagues and to employees and understanding how health and safety operates within the business and understanding any challenges to health and safety in the business. Another which health and safety can be looked at is through things like procurement standards and contracts. Is health and safety a consideration as part of those? It's useful to think about third parties that are involved in business, so contractors or other people who may use your site. How are their health and safety arrangements fitting with your own? How have you shared information with them? And of course, on the do side of things, there's training, which is a really important part of health and safety, to make sure that comprehensive training has been provided, but also understood by employees. Moving on to the next circle in the Venn diagram, check. So you've got your strategy, you implemented it. It's important to make sure and to check that actually that policy is working. And typically this can be done by a series of audits, both internal and external, and that provides a useful benchmark and a useful way of seeing how well your strategy is working. Checking can also occur by collecting data and analysing that data and looking for things like near-miss reporting or for suggestions that can be made from employees about how health and safety can be improved. Move on to ACT, and so that is about the board reviewing those checks that have taken place and implementing any change to the strategy. And really that review should take place at least once a year and examine whether the health and safety policy accurately reflects the organisation's current priorities, plans and targets, and it can also identify any weaknesses that may exist and how they're going to be addressed and a system to monitor their implementation. So there are various steps, various procedures that can be put in place to achieve health and safety through that process of plan, do, check, act. However, health and safety is more than just a series of policies and procedures. It's also important there is a strong health and safety culture within the business. And one of my particularly favourite quotes from a well-known health and safety psychologist is on the slide in front of you. All about the importance of understanding that no matter how good your health and safety training is, how good your health and safety policies and procedures are, is actually about what the people on the ground are actively doing. And if somebody comes into a business, even if they come from an organisation which has very strong health and safety culture, and they see that in fact half the people around them are not behaving safely, and they are far more likely to follow that behaviour and accept that that is appropriate. Sadly, Mary and I, we can see 80% of what we learn is from our peers and only 5% from formal training. So it's really important when you're managing health and safety that you address the culture point as well. So just bullet points here on those points. So health and safety, it's really not just a compliance issue. It has to be an intrinsic part of your business. It's an inherent part of what you do day in, day out. The systems have to be there, but you also have to have the right cultural behaviours. The board needs to be engaged. Health and safety management comes from the top. It is much about active involvement, not passive involvement. An interesting piece of research done recently of board directors, and a number of them said that they felt that they supported health and safety, and the phrase that was used was, "My door is always open." But the problem with that is that it's very passive involvement, and we're looking for people to actively get out there and check that health and safety is working. Thirdly, you need to have that opportunity to test out how your business will actually fare in the event of an HSE investigation. Do you know what your workers, your employees would say if asked by a HSE inspector what your health and safety culture was like or how you approached health and safety? Mary and I are now asked to go and do a compliance legal review, so we will go into a business and look at how an HSE inspector would view that business should an incident occur and make recommendations for improvements. Finally, it's really important that you plan for the crisis, have in place some procedures for when something goes wrong. Think about that crisis management policy. You're not looking for reams of documentation, but some simple checklists and simple things like making sure you've got the right contact details for people can be really useful, so you have then thought about how you are going to manage that crisis.
Concludes our webinar. Hopefully you have found that's given you some useful technical information, legal information to go and speak to your businesses, but also a number of practical tools. Our details are up on the screen in front of us. We will be more than happy to answer any queries that you have. Thank you much.
Thank you.